Started. Okay. This is the November 3rd meeting of the Post-Conviction Relief Performance Standards Work Group. And I'm going to pull up the current document that we've been working through. If I can find it. Yeah. Meg. Hi, Meg.
Hey.
Just getting started, taking a look at the document where we left off. You all tell me, but I think we kind of gotten to the trial itself, unless there was more we needed to add in. I think last time that petition pre-appeal, I don't think actually maybe doesn't go here, but is a note that is to be incorporated elsewhere in this document. So then I think we had gone through the things that need to be included in the defendant's trial memo. So I don't know if there's something after that or more to put in that before we get into trial. Or we can jump right into trial. I think we had previously talked about client's appearance. Then I don't know what else goes in here other than, I mean, offer exhibits seems obvious.
For the trial piece, I think, like I said, based on my recent experience with the judge not allowing me to waive my client's appearance, I just maybe indicate to them that some sort of indication that, I don't know, they should look into it. Ed, what is the statute for the client's or the petitioner appearing?
This number?
Yeah.
I'll pull it up, but I think it just refers to remote appearance. Like it says if, basically they have reason for them not appearing in person and that it has to be simultaneous electronic and allow private conferral. I don't think there's anything beyond just creating that exception because it's from that old time when in-person court appearances were expected. But I can get you the number.
I'm a little bit worried about the part that says, unless granted authority to do so by the client. Because if the court orders the client to appear, then I don't know if it strips your client's ability to waive appearance.
It's ORS 138620. And that says that the circuit court need not order the petitioner be present if the hearing is just about a demur or motion raising solely issues of law. But if it's issues of fact, then the circuit court shall order petitioner be present.
Yeah, so I don't feel comfortable saying that they can waive. I don't know the answer, so I don't know if we can say they can waive their client's appearance.
Yeah, and I think the Court of Appeals hasn't been super clear about that.
Yeah, and I don't know, it's odd to me because I know of lawyers who've done jury trials without their client present. I don't know if there's something more in the ORCP, but it seems strange to me that you have jury trials sometimes without even that plaintiff present, and that the court would refuse to proceed with the petitioner waived. Now, that's not to mean they wouldn't do it, but there may be something else that you could argue in the ORCPs or somewhere else.
In my understanding, where it comes from in the civil rules is from the failure to prosecute piece of it. And if your client doesn't show up, then they're failing to prosecute their case. In the criminal context, I think it's different. And so what the judge did in my case is they ordered my client to sit there, but he could have it on mute if he wanted to have it on mute, but he at least needed to show up, which kind of reminds me of, when a criminal defendant is disruptive in court and they put them in their own area to watch the proceedings. So I don't feel comfortable with unless granted authority to do so by the client.
Do you think we should eliminate it or replace it with different language?
Maybe just reference the statute, and each person would have to, I mean, because I don't see that same, like the court could say, okay, I'm ordering the petitioner is appearing through counsel. Like I don't see anything where the court couldn't say the appearance is through counsel, but I think if I understand what Ginger's saying, I would agree with that. We can't assume we can decide that without the court.
Yeah.
Yeah. There definitely have been cases where the trial courts do allow counsel to waive appearance of their client, and the Court of Appeals has not reversed those. Yeah.
And do you know if those are situations where the court ordered the petitioner to appear?
Yes.
Okay.
Yes. If the court doesn't order the petitioner to appear, I think that's what Frost says. I think that's reversible.
Right. Yeah, that's my understanding. If they don't order them to appear and they don't show up, and then you
proceed
and then they dismiss or proceed, then that's reversible.
Yeah.
I personally don't know enough about the waiver issue to want it to be able to comment with regard to the black letter.
Yeah, I mean, I don't think there is clear black letter law yet. I think that's the problem. And courts are doing it differently.
Mm-hmm. I would just say consider ORS 138-620 when determining or for petitioner's appearance or something like that.
Okay.
I mean, that is the black letter. They need to be familiar with 138-620 and 138-622.
My understanding of the case law, the jurisprudence says the ORCPs apply unless the PCR statutes say otherwise. So, I mean, it's arguable that the PCR statute covers this. I know what the ORCP says is that if you fail to appear for trial, the court can proceed without you. It doesn't say they can dismiss it for
I like that
non-suit or failure to prosecute. It just says they can proceed without you. So seems kind of crazy that, but it's ORCP 58 58E is failure to appear for trial.
58E. Okay. Okay. I think the best practice is still the best practice. I think that's fine to keep in. So under client appearance, should we just take out the little? Should we take out the client appearance piece?
Yeah, that was more, I think, notes related to
Okay,
the
okay,
above,
okay,
so,
gotcha. Sorry, I didn't know if that was part of the end product.
no, I don't think so.
Okay.
I think we're just kind of throwing in everything we're thinking about trial, and then I'll get it coherent at the end.
I guess in terms of like the black letter for trial, you need to make sure that you've subpoenaed the witnesses that you want there. And that includes witnesses that you need to cure hearsay objections. In terms of, I mean, at the trial, you should argue your claims to the extent necessary. I don't know that there's a black letter with regard to that. I thought we talked about this last time. You know, if it was sufficiently briefed, then do you need to spend a lot of time arguing it?
Yeah, I think we might have talked about that in the context of what goes in the trial memo. But I think you're right. We discussed what's the difference. What are you briefing versus what are you saving to present? But I don't know if we discussed putting any directives in the trial section related to that.
Yeah, and I don't think you save anything. I mean, you have to argue everything in writing, or you should argue everything in writing.
Yeah, I think I brought up last time, and I'm not sure where we put this, but just that sometimes the state's response, or that state's evidence, like trial counsel's declaration, can kind of change what the claim needs to be. From like failing to do something to, this is what I see regularly, is like to failing to like execute a strategy versus failing to have us make a decision about something or have a strategy about something, failing to like reasonably execute the strategy they had. And so that's something that like at trial, you can kind of reframe the claim and then ask that your petition be like treated as if it had been amended. Or
I think that's
petition.
kind of what this note here is trying to get at. And then I think I actually somewhere else put that IAC related point more specifically.
Great.
I guess you should, since the defendant superintendent doesn't have the opportunity to respond to your, I guess your reply to their trial memo, they sometimes respond to the response to the defendant's trial memo during their closing. And so you should be prepared to have the last word on your arguments, but you just know, you don't know what that's going to be. And many times their arguments don't change from their trial memo. Again, this is just how I do things. I don't know if it's best practice or black letter, but I always reassert my claim for, not my claim for relief, the relief requested. I guess you could do, offer testimony.
I don't know if we covered this elsewhere or covered this already, but ORS 138.622 has the fact that it's petitioner's burden of
Oh.
proof, and that it's facts by preponderance, and it talks about received proof by affidavits, depositions, oral testimony, other competent evidence. So I think if we haven't mentioned elsewhere, it might be useful to reference the preponderance standard as well as the burden. And for applicability of the Oregon Evidence Code, I've always just referred to OEC 101, that, you know, evidence code applies, that it falls in. I don't know of any other authority that would say that or state that, but, you know, obviously there in criminal cases there can be some differences, like, you know, sixth confrontation clause, that kind of thing. But I think just the fact that OEC 101 says the evidence code applies, and they, with the exception of those, you know, affidavits, things like that in the statute.
Meg, do you know the case off the top of your head that says that you can amend pursuant to, not pursuant to, but in accordance with like the evidence that's come in, and you know, if the other side responds? I'm just wondering if we should put that.
Yeah, there's Ogle.
Yeah. And I think I have briefing on that.
That's related to the thing you were mentioning a minute ago, Meg.
Yeah.
Just it might be
Ogle-
good for them to familiarize themselves with that case.
Yeah, that's a good idea.
Is Ogle OGLE?
Yes. It's Ogle v. Newth. And let's see if I can find it.
I think it's all based on ORCP 23B, which is amendments to conform to the evidence. I don't remember that one, but I think it's
That's the wording I was looking for.
And Ogle v. Newth is 365 Oregon 771.
And I think it's just, isn't it just NOOTH?
Oh yeah, NOOTH. And that's if an unpleaded issue is tried by express or implied consent, the issue shall be treated as if it had been pleaded. But it refers back to, yeah, the ORCP.
So just in terms of kind of the schedule of events for a PCR hearing, it's offer exhibits, opening statements, presentation of evidence, and then closing. I mean, hopefully people would know that. And the closing is, you know, petitioner goes first, then the defendant, and then the petitioner has the last word.
and I don't recall if I've had new rebuttal during a PCR. I certainly had habeas cases where I had new, so we may have done exhibits at the beginning, but then I may have had rebuttal that came before closing argument.
Oh, rebuttal evidence? Okay,
Yes.
Yeah, I've seen that in PCR cases.
I guess that makes sense.
Maybe just in habeas.
Yeah, that makes sense. I mean, I could see it mostly where you would maybe call your client to rebut something that the attorney said, or call your, maybe recall your expert if the
Sure.
defendant put on.
You know, the other thing I've seen in some PCR, lengthy PCRs, is a closing memo that's, you know, the court points and authorities submitted and before the opinion comes out.
Would that go in the what will be next, the obligations after trial, or is that still, should we
I
lump
think
that in
it's
with
trial. I think it's trial because you would normally ask for supplemental briefing at trial. And it could be supplemental closing, or it could be additional authorities. Or if you just run out of time for closing, a lot of times you can ask, well, you can always ask to submit a written closing. Sometimes they say yes, sometimes they say no.
I feel like when I'm writing some of these parts, like that, like just the structure of trial, that's neither a black letter nor best practice, really, right? That's more of just like FYI.
Yeah.
Yeah.
So
I
maybe
guess
it just comes out.
Yeah, I think some of it I might end up editing just because that is important to know, but this isn't a bench book.
Exactly.
Okay, I just wanted to make sure we're all on the same page. Does that do it for trial, or should we move on to obligations after trial?
I can't really think of anything else.
Yeah.
Can always see how it's looking when I put it in context and see what's missing then. Okay. Potentially final section then.
So something that we've been running into is the courts are not issuing their opinions within, I can never remember if it's 60 or 90 days. But it's our practice, and I know that this differs, but to remind the judge, actually I think it's the PJ, if you've been waiting on an opinion for a long time.
There's a
Okay.
UTCR, and I can pull it up. The 60 days, I think, is to tell the trial judge, and I think the 90 days is to tell actually the Chief Justice.
Okay.
I can pull up
Yeah,
I don't know of a statute. I know what's in the UTCR. I can pull up.
And I think that's what my assistant always sends those out, so I don't know the rule off the top of my head.
I have it here because unfortunately I've got cases that are
Yeah.
very old right now. It's UTCR 2.030. And I think it's a 60-day and a 90-day tell the trial judge. And it doesn't say like must be issued. It just says you should notify a trial judge. And I think Chief Justice, but I'd have to pull it up, which I've yet to do. I've yet to notify the Chief Justice. I've sent a second email to trial judge about, hey, this is what the UTCR says.
And really, it's just depending on the case. If it's a case with thousands of pages of transcripts, then it's more understandable. But if, it's a pretty simple case, then it shouldn't take a year.
And I've been assuming, I've never seen the defense do that, which I think is probably I think it's probably by design. What do you think, Ginger? Do you think
I
they're
agree.
Yeah.
Well, I don't know. I don't know if it's by design or if it's because they have other things that are taking up space. I just don't know that it's that important to them.
You don't think it's like my kids have been remarking recently in soccer that the other team's coach goes, go shake the referee's hand. You don't think it's one of those, we shake the ref's hand all the time? You know
I don't know. My assumption was that it was more of a too much to do, too little time.
I don't know. Their staff members don't seem that busy to me.
That's sure.
They're nitpicking on stuff.
Sure. Yeah, and I used to be concerned about, oh, if I ask the judge to hurry up, that they're gonna rule against me. But I'm not as worried about that anymore. If you have strong facts, you have strong facts.
And I apologize for the digression. We just seem
No,
and we seem to have a PCR cases being handled by one particular person who may need a little reminder from the Chief Justice.
Yes, yes. And I'm guessing that we're having similar issues with the same judge. And I think it's because that particular person has been relieved of he's fulfilled his Plan B duties.
Oh no, there's another one.
Okay. We've been pretty on top of things in terms of just asking for their opinions when that 60 days runs. So, yeah, anyways, I think people should know that it's an option and then they can decide whether or not to exercise it. I would say another obligation is to notify, you got to send your client the judgment as soon as it's issued and then notify the appellate attorneys. And it's been my experience that they file the notice of appeal, but I don't know if we want that in the best practices or in the black letter that the appellate attorneys will file the notice of appeal.
That's what we prefer.
Is that you do it?
Yeah, that we do it. If the client, the client can, or trial counsel can, if it's trial counsel, I guess that's fine.
Can we just say ensure that the notice of appeal is filed?
Yeah. But I think there's something on OPDC's website that sends it to us.
Yeah, I always submit online referral and
I think that's what goes. Yeah, that's directly linked to Equal Justice Law's email address. So we get all of those referrals directly sent to us, and then we file the NOAP. If the client files the NOAP, we usually just file a amended one just in case to make sure there aren't any deficiencies. Yeah, and it's fine to have, the trial attorney can file, but we do take care of that, assuming it's appointed.
Right.
Is what this is. So that's, yeah.
Oh, that's a good point. I was thinking of other situations, but
Yeah.
But you can be appointed not through OPC also.
Is that true? Yeah, okay.
Yes.
Or
Are you talking about Oregon Post-Conviction Consortium? Or
no.
Oh, okay. Okay.
For the appeals.
Gotcha.
Yeah, I'm not in the consortium. It goes through Public Defense Commission like a criminal appeal.
Okay. Okay. I'm sorry. I thought when you said the website for OPC, I thought you were talking about Noel's group.
Sorry, no.
No, apologies. It's you can select habeas, delinquency, dependency, criminal, and yeah.
I think all of those. I know there are certain types that get sent to other attorneys, like aggravated murder generally goes not to us. But I think it still all gets funneled through. I'm not sure, I guess. I could find out. And I guess, it's possible that all of this will change. We have a contract now, so this is how we like to do the system, but I don't know that we should build that into to these guidelines.
Yeah, it probably
just
makes
so
sense, as
no,
Ginger
yeah.
suggested.
Well,
Just
and
make sure it's filed.
Make sure it's filed. Yeah, that's
No,
fine.
Colin, I think it would be the same as whatever you're writing for criminal, because when I used to review the firm, and the same thing I did with my criminal appeals, I've just started doing my habeas and my post conviction. So I don't know how it's written up because my understanding really was that it's not in my scope to do the notice of appeal when I'm appointed, just that I refer it, but I imagine it would come back to me if it didn't get filed on time. But maybe we can reference whatever they're putting in the criminal standard when it
I
comes to
think,
that.
I mean, I think the criminal standards are going to be a little bit different in the sense that those will go to OPDC.
So my
I
referral
guess
does
it's
as
the
well.
same.
OPDC just
It all
happens
goes-
to be contracting those to Meg's firm, but
Yeah.
that's just a
It
choice
still
they've
goes
made
to
internally to
OPDC.
contract
Okay.
them. It's still
Yeah.
Okay,
yeah,
that
it may
makes-
directly go to their office, but it's the exact same form. You just are selecting
Yeah,
habeas
that makes
PCR
sense.
rather than criminal.
Yeah. And then if like
Okay.
anything changes with that, it'll still go. Like it should still get funneled through OPDC first.
That makes sense. Again, black letter, maybe not. I'm sorry, maybe this is just best practice, but I think you should send your client a closing letter. Just like you would do in a retained case with regard to, file retention, all those different things.
Yeah, I would say the closing letter. I think it makes, I don't know if you guys do this, but it seems like it makes sense to mention federal habeas exhaustion requirements and needing to appeal if you want to proceed.
And then there's, I guess, your obligations to client if they request their file. And I think you're required to turn it over with some caveats. And again, maybe this isn't black letter, but you still have to redact all of the necessary witness information. I'm sorry, victim information. And then there are certain ODOC rules that you have to adhere to, and how I've dealt with that is, well, I actually can't remember how we deal with it, but like really sensitive photos, autopsy photos, stuff like that, you can't send into ODOC. So I think the practitioners just need to review ODOC requirements with regard to sensitive case information. And then we should probably refer to the rule of professional conduct with regard to how long you keep files. So I think that it's 10 years or the length of incarceration. But I'm not sure. I need to look.
Oh, also, if you win, right? Have we put that
Oh,
in?
yeah. Yeah.
If you win, you have to file a certified copy of the judgment in the criminal trial court.
And to the DA?
Two, yes. One to the trial court, one to the DA.
Yeah, the statute refers to notice. Let me pull up the statute because I was lucky to find one that I could copy and I had it come up that I mod, but it's like I do a letter, I do a notice, and then I file them. It's RS 138.640. Then it's certified copy of the judgment in the court where the judgment was rendered, and then serving copy of judgment on the DA.
that do it?
I was just looking at trying to find the retention requirements.
I think you have to, I think you have to file the notice. You send it to the DA. I think you have to actually file the notice that you send it to the DA.
Yeah.
It's the court of conviction. So trial court, it's the one of conviction as opposed to the PCR trial court.
You may also include that if you have a partial win, and the client wants to appeal the claims that they lost, you can still go ahead and file the certified judgment for the winning claims and also the appeal.
Junior, what if anything do we want to say about objections?
Oh,
That's a good idea.
like to the findings of facts?
Yes.
Or I guess the ruling?
They're
Mhm.
ORCP, are they 58? Let me see. ORCP.
I mean, Meg, have you seen that come up as a bar in an appeal? Where
Yes.
somebody didn't object? Okay.
Or it's at least something we then have to argue about preservation. I don't know that usually it's like a DAT claim where the judgment doesn't cover doesn't explain the basis for denying one of the claims. And those have gone through on plain error.
Okay, so what do you think the best practice is?
I mean, I think objecting is the best practice. It doesn't, I mean, winning on a DAT claim on appeal doesn't get you any more than if you object and note the problem and the court fixes it then. Right? Yeah, that's true.
Sorry, when you're saying objecting, you're saying if the trial court is
So like
making
any errors
factual
in-
finding during the trial, or are you saying that there's a judgment and at the time of the judgment, you're objecting prior to the
Yeah. Well, I
filing
guess
notice?
what I was thinking about, maybe Ginger and Ed were thinking about something different. Was that like the judgment gets circulated for any objections before it's officially
Oh.
entered. So not always, but it can. There are and if there's like some kind of basic error with the judgment and it doesn't get objected to, we end up having preservation issues on appeal, which sometimes it's not a big deal and we can win those preservation issues, but not always.
So would this go in, is this still essentially part of the trial? Sort of? I guess not really.
I think
If
this is
part of,
after. it
Yeah.
seems like
Because we're
that's the right.
because we're
It
saying
sort of falls in between judgment and appeal. It's not yet appeal. It's in between judgment and appeal issue.
so. And
But-
so, in your hypothetical, Meg, this would only apply if the judgment were circulated prior to being published, which
Right.
sounded like doesn't always happen. But if it does, and you're given the opportunity to object, you need to.
Yeah. I mean, I don't know, Ginger, do you?
I'm trying to think of what would be a basic objection, like if the judge got the burden of proof wrong.
Right. Yeah. Yeah. If
I'm
there
just
was
trying to,
like,
like,
applying the wrong
this-
legal standard.
yeah,
Although I don't know if
I just don't,
that's an issue for appeal that I don't think we don't run into that kind of thing as a preservation issue.
I'm just trying
Because
to
he's
think,
presented the correct.
yeah,
know,
if we let's like talk about the facts. So if the court adopts the defendant superintendent's facts as opposed to your facts, should you object to their findings of fact if if the two are different?
I think the only time that would make sense would be if there was like truly a
Difference.
like a real fact that was like that the court just actually gets some undisputed fact wrong. Right. I mean, I think if the court makes fact findings that are not in your favor and there's evidence going both ways, like the court, that's not an error for the court to
Right. Okay.
make
That's
that
just-
finding. If there's
That's
evidence
just trial.
one thing and the court makes a different finding, that might be a place to object. We can also raise that on appeal. But if there's like some mistake, right? Like if the court makes some basic mistake that is undisputed, it probably does make sense to fix that to object.
Okay.
I think I mean, I don't know how receptive trial courts are to that kind of objection, but I imagine if that got fixed at the trial level, it'd be easier to get it fixed at the trial level than the Court of Appeals. Because we have a standard of review issue.
But you don't necessarily have to object to the court's, I guess, opinion on your different claims, because isn't that what you
Yeah.
argued? Okay.
Yeah, totally.
Okay.
No, I think, and like the only one that I can think of off the top of my head as being an issue is when it's a claim where, for appeal, the claim is that the court erred in not explaining the basis for each of its denials of relief, that like it misses one of the
Yeah,
claims. It
I
doesn't address
understand.
that. Yeah. And that's one where we have had to argue it as plain error rather than not needing to be preserved.
So I think maybe the black letter is that trial counsel needs to make sure that the court has addressed each claim for relief.
Yeah. That's good.
In the judgment.
But only if, I mean,
Only if it's
obviously,
circulated ahead of
only if
time.
it's circulated. Yeah, okay.
Yes. If there's an opportunity to object. Yeah.
Yeah.
Yeah, and I feel like the fact finding stuff, that's sort of like you could do that if you wanted to, but I don't think that feels like more of a strategic and just your judgment kind of thing.
And Judge Burton in Marion County, well, I guess she's not in Marion County anymore, but I just remembered, she has been ordering both parties to file a findings of fact and conclusions of law, I think with their trial memo.
Yeah.
So maybe we should put that up in the beginning, that if,
Interesting.
or I don't know, maybe you should just read the scheduling order and do what it says.
I think we had that in there actually.
Yeah.
I think.
So that's probably enough.
Well,
Okay.
this is good. I will make it a goal to have this all converted into a document sometime in advance of next meeting, hopefully then enough time in advance for you all to take a look at it, but it'll also probably be a little long, so I don't, especially if I get it to you late, we can just go over it in our next meeting.
My last thing is, do we want to put anything in there about communicating with their federal attorneys?
You mean in the event that you have an obligation to work with them if they end up with federal attorneys down the road?
I don't know if work with them, but just provide your file. But I mean, you're required to provide your file. To anybody that they want. Oh, I don't know.
All right. Well, I'll try to get this cleaned up and I'll circulate something and hopefully we're pretty close.
Sounds good.
All right.
Sounds good. And end a few minutes earlier today.
Okay.
Thanks.
Thanks all.
Bye.
Bye.
Bye.